Hi, my name is Puyan Darian. I'm an immigration attorney and I help people apply for citizenship and permanent residence all day, every day. Immigration is all I do. Today I want to talk to you about a question I've been hearing a lot recently, and that's whether or not somebody who marries a US citizen can get deported from the United States, either immediately after marrying or while an adjustment of status or green card application is pending. Okay, so I'm going to slightly rephrase the question. So the question is whether marrying a US citizen offers any level of protection from deportation. Still a pretty complex question, which I can't explain in complete detail because that would take several hours, but I can go through the most common questions I receive pertaining to this subject. All right, I want to start by making a distinction between three groups of people who are in the US. The first group this does not apply to the first group, and that would be people who unlawfully entered the US, right? That's either crossing the border or entering with a fake visa or something unlawful. The second category are people who entered with a valid visa. A good example would be a B2 tourist visa or an F1 student visa, something like that. These people went to a consulate, got a visa visa placed into their passport, and then they used that to enter the US. Those people are in the best situation right now, generally speaking. The third category is people who entered on some sort of visa waiver program or ESTA. Typically nationals from Canada or certain European countries can enter the US without going to a consulate. They just apply online and enter, and it's generally for durations of 90 days without ever entering with a visa. They entered on a visa waiver program or something similar. The third category, when compared to the second category, that would be people who enter on a visa versus a visa waiver program, are always in a better position than people who are here completely unlawfully. But the visa waiver program entrants, or people who don't have a physical visa in their passport, those people are subject to expedited removal when the duration of their stay expires. So let's say you entered on the visa waiver program. You have 90 days here lawfully, and you're here until day 91. As of day 91, you can be removed from the US without any right to a hearing or other due process rights which might otherwise attach. If you're here with an actual visa, for example, you have a tourist visa in your passport, you entered and were stamped into the US, you'll generally get 180 days. And on day 181, you still have certain rights and privileges if the government tries to forcibly remove you from the US. I know that's a complicated distinction, but to simplify it, people who enter and who physically have a visa in their passport are generally in a better position than people who entered on some sort of visa waiver program. That's the main distinction I want to make. Now, let's say we have a situation where someone's tourist visa, the visa which is in their passport, is about to expire. And at the same time, somebody else who's in the US on a visa waiver program, their duration of stay in the US is about to expire. So these two people, one with a visa, one on a visa waiver program, their status here is both about to expire on the same day. Who's in the better position? Generally speaking, I would prefer the client who has a tourist visa or visa in their passport, because I can assert more defenses if the government comes knocking and asking why they're still present in the United States. In reality, both applicants can still apply for adjustment of status if they're married to a US citizen spouse or have another qualifying family member. And I do that for my clients. I help them apply for adjustment of status in both of these situations. But I would generally be advising the spouses who have, where the immigrant spouse is in the US on a visa waiver program, that there are heightened risks attached. I have seen situations where people have overstayed their lawful duration of stay in the US, and now they're married to a US citizen, and a year or 2 years later, the Department of Homeland Security sends them a letter asking them to come down to the federal building with their passport and their suitcase to have a conversation. Oftentimes, actually the 2 last times this has happened, I was able to resolve it by contacting the Department of Homeland Security officer, showing them that the immigrant spouse is now married to a US citizen and has a green card, an adjustment of status application pending. And in both of those 2 last situations, I was able to have the Department of Homeland Security officer drop the case. Basically just said, thank you for sending us these documents and best of luck to your clients. So those were 2 positive outcomes in recent times. I expect the situation to slightly improve in the coming months, but my point is, there are times where the Department of Homeland Security comes looking for people who've overstayed their visas. And generally speaking, I've been able to resolve that by showing that there's a valid adjustment of status application pending. So remember, if you marry a US citizen and you entered the US lawfully with some sort of non-immigrant visa or visa waiver program status, you've probably taken a step in the right direction so long as it's a good faith marriage. But that by itself does not offer the protections you want. I would highly recommend that you speak with an attorney to see if filing an adjustment of status is the correct course of action at that point, because that is the application which may actually offer some relief. And eventually at the end of the tunnel, you'll probably get permanent residence out of it if you qualify. But even while the application is pending, there may be some practical benefits, such as being removed off the Department of Homeland Security's enforcement priorities, which could give you some space to breathe while USCIS processes and adjudicates your application. If you have any questions about any of this, you need an attorney to go through the process with you, or you just don't understand exactly where you lie on the continuum of different entrants who've entered the US and what their status may be at this time, I'm happy to break it down. I would need to get all of your facts and circumstances during a consultation. We'll go through everything, create a strategy and plan of attack so that we can maximize these outcomes for you and you can get your permanent residence and employment authorization as soon as possible. Remember, I'm Puyan Darian. My team is always here to assist you. We handle cases virtually in every state in the country, and you can always book us by calling, texting, or going to our website. Thank you.